President Jacob Zuma was yesterday granted leave to appeal last week's court ruling overturning his medical parole. Just a week ago, Justice Elias Matojane found that the decision to release him was unlawful, but yesterday the same judge arrived at a different outcome, saying another court could arrive at a different conclusion to his previous ruling. To some people, this may be confusing, and so today we've invited Patrick Kadima, a research fellow at the Public Affairs Research Institute, to outline just how some parts of the legal system in South Africa work. Mr. Kadima, thanks so much for your time on SABC News this afternoon. So let's start with it. How does the system of law in South Africa work, and what kind of system are we using?
So thank you, Zinga, and good afternoon to your viewers. So first of all, South Africa is a mixed or hybrid common law system. So our legal system draws from various legal systems such as the Roman Dutch law, the English common law, and the Roman law. And just to also state that we, of course, have other main sources of law, main sources of domestic law that we use. So, for example, the Constitution, which is the supreme law of the country. We have legislation, we have common law, we have conventions, you know, that our government sign, for example, at the UN, and so those include like treaties, and we have customs as well as case law.
All right, so what criteria do judges then use to determine whether a party can proceed with an appeal or whether they'll be successful in those kind of applications that we're speaking about?
All right, so briefly speaking, so Section 16.1 of the Superior Court Act is what guides us generally on appeals. But then when one goes on to Section 17.1 of the Superior Court, it speaks to the criteria that one judge can consider in terms of leave to appeal, and that is the appeal would have a reasonable prospect of success. So this means, and we saw yesterday during the arguments, that it's not may, as other people have stated, but what the Act states is that an appeal would have a reasonable prospect of success in another court, you know, or another court will arrive to a different decision. The second thing is that there is some other reason, one other criteria is that there is some other reason why the appeal should be heard. So, for example, it might be that there is conflicting judgment on the matter that is under consideration.
Mm-hmm. So, Patrick, what checks and balances are there in place to ensure that there is fairness for parties who may feel wronged by rulings that they receive?
All right. So, for example, if one is in a high court and they are litigating in the high court, and one party feels aggrieved that they are not happy with the judgment or the order of the court, they may seek for leave to appeal on the matter to a superior court. And the other one is, for example, in the magistrate, you can take your magistrate judgments or orders to a superior. I mean, you apply for a review to a higher court, which will be ordinarily a high court. Then you can also apply for what we have seen in previous cases, what we call a rescission of the judgment. So these are some of the avenues that parties that are litigating, if they feel that they are not happy with an order of the court or a judgment of the court, they may they may use one of those venues. And obviously those avenues have requirements. For example, in terms of rescission and appeal. So they are not the same. They have the requirements of a rescission are more narrow than a requirement of an appeal. Because for an appeal, one can try to appeal a case on the basis of the merit or of fact. But when you are speaking of a rescission, there are different requirements that are applicable to that.
Patrick, How much of justice is determined by how much money one has in South Africa? I know the Constitution says we are all supposed to be equal before the law, but it appears that people may not get access to good attorneys depending on what they have or what they don't have.
Yes, indeed. Access to justice in South Africa and in many developing countries remains a dream for many people. The downtrodden, do not have access to finances to be able to pay lawyers. So, for example, I'm just going to give an example. We have seen court cases involving informal traders, and these court cases involving informal traders have been taken by legal aid clinics, have been taken by law clinics that operate within universities, as we have seen, or have been taken generously by people who want generous practitioners who want to take it pro bono. So it really remains a dream for many. And justice in South Africa, obviously, I will say that if you have the money, you can take your case to appeal. You can get the best lawyers the country has to offer and pay them the amounts they need. So for example, so I think the issue that we have is to make sure that our legal aid programs continue to grow. We ask also for legal practitioners to take on cases pro bono to help people who do not have the finances to employ the services of legal practitioners. So, for example, I think also our law clinics and various legal aid clinics around the country are also strained because of finances. They depend on donor funding, and as we have seen during COVID-19, donor funding has been cut a lot. So that sets us back in terms of trying to fulfill the reality that access to justice should be for everyone and not the preserve of the few.
Patrick Kadima, a research fellow at the Public Affairs Research Institute. Thanks so much for your time on SABC News this afternoon. Just outlining how the South African legal system works, what it's made out of, some of the challenges that are facing it, and of course, what you need to be successful in an appeal.